to the In the Sweetgrass with Misty Flowers. In the Sweetgrass is a video podcast that was created as a way to document and share our culture at a wider level. Misty Flowers is the executive director of NICWIC. She is a member of the Santee Sioux Nation of Nebraska and is a descendant of the Tlingit of Alaska and Ho-Chunk.
With special guests Robert, Jill, and Alexis.
Welcome, everybody. Good afternoon, and welcome to another episode of In the Sweetgrass. I'm Misty Flowers, the Executive Director for the Nebraska Indian Child Welfare Coalition, and today I have with me Robbie McEwen with Nebraska Appleseed. We have known Robbie for a very long time. We were just talking about when we worked on the changes to the Nebraska ICWA back in, well, it was passed in 2015, but Robbie was really, really vital to that. And then we also have Alexis Zendejas. She is the ICWA attorney for the Omaha tribe of Nebraska. And we also have Jill Holt. She is the training and education director for the Nebraska Indian Child Welfare Coalition. So we are going to be talking about the Supreme Court ruling on upholding ICWA, and this was, of course, with the Brackeen case. Some of you may be familiar with that. I think to get us started, I would really like for somebody to maybe give us some background and history of the Brackeen case. And I'm sorry, I know I didn't ask you guys about this ahead of time. So whoever has an update or, can provide that history.
Sure, I can give it a shot. Yeah. So the Brackeen case arises out of the state of Texas. It was initially filed by a set of foster parents and the state of Texas, seeking to try and challenge the constitutionality of the Indian Child Welfare Act. And so this case arose in the district court. So there's federal district courts in Texas. They filed this case there. This didn't come through like a regular juvenile court case. They independently filed a case in federal district court and challenged the constitutionality of ICWA on a lot of different bases, but the primary ones being they tried to argue in the district court, and they won in the district court, that ICWA was unconstitutional because the federal government, in passing the Federal Indian Child Welfare Act, had taken power away from the states to regulate their own foster care system or their child welfare system. And so when you see something in the news about anti-commandeering, that's basically what that argument was, is that the feds, Congress, commandeered the resources of the state of Texas to tell them what to do. And then the other really primary argument that the people challenging ICWA had was that it is unconstitutional because it violates the Equal Protection Clause of the US Constitution. Essentially, they tried to argue, and again, one at the district court level, that ICWA is unconstitutional because it is a race-based classification. And that's something that the district court judge in Texas found to be correct. And both of those issues were then appealed up to the Fifth Circuit Court of Appeals. And so at the Fifth Circuit Court of Appeals, that opinion was very confusing. It was over 130 pages long, and many of the judges agreed on some parts but didn't agree on other parts. And so it was something called a plurality opinion. And so the Fifth Circuit Court of Appeals found that the ICWA did not violate the Equal Protection Clause, but it did inappropriately take away power from the states in some respects. So it struck down some parts of the ICWA, it left other parts of the ICWA in place. And so both sides, tribal advocates and the state of Texas and the foster parents in that case, appealed the case up to the US Supreme Court. And so that is the ultimate decision that we're here talking about today. But it was a case, it took many years. The court system is really slow. If you file a case in federal court, it's going to take a long time to get all the way up to the Supreme Court, if ever. And so this is a case that I know NICWIC has been talking about for years is potentially really problematic and damaging for not just ICWA purposes, but tribal sovereignty purposes. If the equal protection argument were successful, there's potentially some concerning consequences there, because if tribal membership were a race-based classification, many parts of federal Indian law, like IHS or Indian Health Services, funding for tribal schools, a whole variety of things are sort of based on the premise that membership in a federally recognized tribe you can access different parts of like funding from the federal government. Many parts of the federal code are based on that premise. So it's kind of a big deal. It was a very big shot at an attempt to try and strike down tribal sovereignty in a lot of ways. And so it was a really, really important case.
I think too, another big part of that, along with the equal protection, was where Congress gets its power to regulate over Indian tribes. And that is also another reason why this case affected more than just the Indian Child Welfare Act, because they were trying to say Congress doesn't have the ability to regulate over Indian affairs. They have the ability to regulate over Indian commerce, trying to go with a really like textualist by what the words explicitly say framework for this case, saying that the Indian Commerce Clause really should only deal with Indian trade, and they tried to go with this really what Amy Coney Barrett in her decision said, like, it's rhetorically great, but legally doesn't make any sense, because by saying that, oh, commerce does not include Indian children, and so by saying that this case, right, or that the Indian Commerce Clause regulates Indian affairs and not just Indian commerce, that would have also affected jurisdiction in criminal cases, jurisdiction in civil cases, land rights, you name it. If this case would have stripped away Congress's ability to regulate over Indian affairs, the entire structure would fall. And I'm not trying to be dramatic; it really is just that dramatic.
Mm-hmm.
Yeah, I guess the only other thing that I would add to that, because you guys are spot on. Justice Gorsuch wrote a concurring opinion, parts of which Justices Sotomayor and Jackson joined, and to sum up what he said in his opening part of his concurring opinion and what Alexis was just talking about, in the process, the court also goes a long way toward restoring the original balance between federal, state, and tribal powers the Constitution envisioned. So very clearly stating, reaffirming that tribal sovereignty, that's a government to government relationship between the tribal nations and the United States federal government.
I really appreciate all of your comments on this. So Robbie or Alexi, whoever wants to talk about it first, kind of diving into, some of the details of this case and how those, what does this mean? What does this mean for ICWA and for Indian country?
Well, I think first of all, it's important to know this is a big victory for Native children and families in Indian country in general, because Lexi's right. The broad consequences of this case are not to be lost, and the interests related to and behind the challenge, like there's been concerted efforts to try and strike down the Indian Child Welfare Act and other laws that support tribal sovereignty for many years now. This is not new. It's a continued effort, and it's likely to continue. And this shuts down a lot of the potential mechanisms that they used, like Lexi mentioned, to try and take away tribal sovereignty. So it is a huge victory for Indian country, and I think honestly one that I was not fully expecting. I was pleasantly surprised, but it doesn't necessarily do away with the future challenges. And so What the Supreme Court did do is they refused to allow the foster parent, in this case, in the state of Texas, to go forward with their challenges because they lacked something called standing. They weren't in a legal case. Generally, you have to show that you're hurt somehow. And the law is the thing that hurts you. And in this case, the Supreme Court correctly noted that there was not standing for the foster parents or the state of Texas to try and raise the types of arguments that they were making, which is really good because those folks, like raising those claims in a federal court, would be very bad if those types of claims could go forward in the future for land rights, for a whole variety of things. So that was great.
And Robbie,
oh, go ahead.
Sorry, Robbie, just to stop you briefly, isn't it accurate too that by the time this case reached the Supreme Court, all of the adoptions were finalized with the families who were claiming that they had been wronged?
Right.
Yeah.
Which I think ironically directly undercuts like the point that ICWA opponents are trying to make, is ICWA prevents Native kids from being placed in anybody's home but a Native family. And that's not actually super wrong, because ICWA focuses on tribal membership, which is a political affiliation. It doesn't focus on whether you are Native or not. And those in Indian country probably know each tribe has a different membership criteria. And so it is not a race-based law. Whether or not ICWA applies to you depends on whether you're eligible for membership in a tribe. But all of the children involved in this case were actually eventually adopted by non-Native families. And anybody that's had an ICWA case knows that like ICWA provides procedural protections for Native families and children. If you're a member or eligible for membership in a tribe, it does not prohibit Native kids from going to white families. It provides protections that the state has to go through in order to make that happen because of the historical and continued abuses by the state and private actors that have failed to follow any sort of procedural protections before. But it sort of lays out the protections that exist for those families to try and protect that cultural connection. It doesn't prohibit really anything. It just tells you the steps that you have to go through.
I would also add that, so there were 3 families involved, one from the state of Texas, one from, I'm going to say Louisiana threw their hat in there. I'm not sure that the family was from Louisiana, and then Indiana threw their name in, but I think the family was from Minnesota. So the Brackeens and the Librettis both adopted their children. And then the last family that was involved, the Cliffords, they didn't get to adopt the child, but that's because it went to a biological grandmother. It went to the maternal grandmother. So, and in that, even in non-ICWA cases, a close family member like a biological grandmother, like I said, ICWA aside, does hold preference in any child welfare proceeding. So the court also said not only did they not have standing on the basis of that there was no injury in fact, there's no redressability. So the court isn't going to be able to remedy something that went their way anyway or wouldn't have gone their way regardless of ICWA.
Yeah, I think that's an important point too, Lexi. Like the ICWA, Nebraska has its own state ICWA, and then there's the federal ICWA. Both statutes have placement preferences, which is one of the things that was under attack here. And the first placement preference, there's multiple rungs, but the first preference in ICWA is placement with extended family. And so that actually, in non-ICWA cases, is also true too. In the state of Nebraska, we prefer placement with kin or kinship placement. So people that are known to the child are much preferable to placement or adoption with a stranger. So even in a non-ICWA case, if auntie or grandma or uncle step up and are available for placement, under our state law, whether it's ICWA or not, kids should be going there before you like start to explore. Let's see who is available out of like the pool of strangers that are able to like foster or adopt a kid. So whether ICWA applies or not, that is what we do as a state anyways.
Thank you both so much. I really appreciate that. So you all were talking about how like this would possibly have implications on for federal Indian law and policy. So Lexi, I was wondering if you want to talk about that a little bit more.
I can definitely touch on it. Yeah. So like Robbie was saying, the two really big arguments that the state of Texas and the foster parents were claiming was on the basis of where Congress gets their power. They're going right for the heart of this thing. They're saying, well, ECWA shouldn't exist anyway because you, Congress, the United States Congress, don't have the authority to act here. And then the second one was what Robbie was talking about, was those equal protection claims. And so the bigger picture here is that really, if you look at ICWA, the Indian Child Welfare Act hits a lot of, we'll call them like basic federal Indian law principles, right? And so one of them is the plenary power of Congress. And Texas was saying, you know what, like I said, you guys didn't even have the authority because your bucket of power, this like narrow power that you have from Article 1, Section 8, Clause 3, where it talks about where Congress has the ability to regulate commerce with foreign nations, among several states, and with the Indian tribes. And that goes back to like a foundational Supreme Court case out of the Marshall Trilogy, saying, hey, we don't really know what Indian tribes are, but this case said, well, they're going to be called domestic dependent nations. They're going to have inherent sovereignty, but under the guise of, like they said, like a ward, like a ward to their, you know, we're in the family law context here, basically like a foster, like a child to their ward, right? So with that basis, Congress said, okay, well, if we are defining what Indian tribes are, and they're under the guise of the federal government, we have the ability to regulate that. Congress started with this idea that we have like this power to regulate over every aspect of Indian affairs. And Texas said, no, it's just commerce. They try to equate it to the interstate commerce clause, where it's really only has to do with like financials and trade and that kind of thing. And the Supreme Court said, no, it has to do with Indian affairs. And so that means that it has to do with the people that make up the Indian tribe, was their argument. And if we were to strip back Indian affairs to only mean Indian trade or trade with the Indians, then Amy Coney Barrett touched on all of these aspects of the law that would be stripped back. The Congress would have no power to regulate, including domestic violence, including criminal law, property law, just a bunch of different facets of the law, because Indians touch every part of the law because we are people. And so if that were to be stripped back, then every part, you know, of whatever Indians touch in the law would also be stripped back. So Congress wouldn't have power to regulate, and it would dismantle an entire foundational principle.
Yeah. And I think it would be entirely in Justice Gorsuch does such a nice job spelling out the history of the intersection between tribes and the United States government, which it's beautifully written. It is tragic, as you all probably know, about that intersection. But if Congress 150 years ago only had the authority to regulate trade between Indian nations, they probably wouldn't have had the authority to like order the march of 1,000 miles from like one place to another on the Trail of Tears. That would not necessarily be commerce in the traditional sense. And so Congress has historically enacted for good, bad, or indifferent, very broad authority over all Indian affairs. And so the fact that they are through ICWA regulating Indian affairs in the family law or juvenile court context is certainly not the broadest application that Congress has ever done stuff to tribes before. In fact, it's pretty narrow and tailored. specifically trying to focus on like the survivability of tribes and the passage of the federal ICWA. When they passed the federal law in 1978, 1/3 of all Native kids have been removed from their parents' homes and placed in white families. It's the largest genocide that's occurred on American soil ever. And so Congress, in trying to redress the affairs of Indian nations, was trying to ensure that those nations would survive. Because when you remove 1/3 of an entire population every generation from any entity, it is under the United Nations definition, genocide. It's like the removal of one population and the forced assimilation into another culture. That's how you commit genocide. So Congress was trying to remediate that. I would argue, and the Supreme Court agrees, and Justice Gorsuch, I think, really agrees, that is within the boundaries of regulating Indian affairs.
Right. Well, and with that, I mean, he really goes into the boarding school era and the atrocities. He relies on a lot of federal Indian law scholars and professors like Matthew Fletcher and Barbara Atwood. And he also relies on the Marion report and the BIA report. So these are firsthand accounts that are available and to the Bureau of Indian Affairs, to the Department of Interior. Like I said, he really goes into the history of it and how just the boarding school era in and of itself affects every facet of federal Indian law and is the basis by which, you know, natives in Indian country kind of live today. I think there was one story that he told, and I feel like some people may be familiar with it. There was a child taken off of the reservation because living on the reservation is unsuitable. But the reservations were created by the federal government. So Gorsuch kind of, and he really goes into the details of how the boarding school era affects every part of Indian country and how we landed there today. And I think he even says like ICWA tries to remedy it, but it's not an actual remedy. You know, we have to do a lot more than that. And the last, what did he say? Since the 60s, policy on Indian law going through the Supreme Court has just been more confusing than ever. So ICWA is an attempt to remedy, and it's helped quite a bit. But as we see from, I know Kavanaugh's concurring opinion is only like 3 paragraphs. It's just an invitation for more litigation to try and come at these at a different angle.
Yeah, and I think to that point, Lexi, the invitation from Justice Kavanaugh is clear, and I think is concerning. In that and Justice Coney Barrett's opinion did not rule on the equal protection argument, so that is still out there on whether ICWA is a race-based law in violation of the Equal Protection Clause of the U.S. Constitution. And the opponents of ICWA, the several national organizations, the vested commercial interests behind these like continued challenges for the last decades, they've very clearly promised that they're going to continue trying to do this. And so until they can try and strike down ICWA as a race-based law and undermine tribal sovereignty even further, that is still out there. And Justice Kavanaugh, I think in his concurring opinion, said this is a weighty issue and we don't deal with it today, but it's an important one to decide. And so I think it is concerning that this is still out there. It's, I think, something that people need to be aware of and on guard for, like in your own situations, in that like these people are out there and there's a lot of folks that want to try and harm Native kids and families and want to do so and have very like big financial reasons that they would like to try and destroy tribal sovereignty and Native nations. And the attack is still coming. So we need to be, I think, grateful, and I am very happy with the result, but just be vigilant. Like this is not over. Just like Justice Gorsuch said, ICWA is a good first step and a potential like first step in trying to address the atrocities of the boarding school era. But we ain't there yet, and this fight is not over.
No, absolutely not.
I really appreciate both of you weighing in on that, because So I was wondering if it would be a fair statement to say that this was an attack on tribal sovereignty, and I think you both kind of answered that. And that to me, as an Indigenous person, that is scary to me, and to think about how this case, and I've heard some people say that, I think I'm just trying to remember that quote that said, if you want to attack a nation, you go for the children.
And this isn't their first time doing that. I mean, like because ICWA was a remedy for Congress and, legislative policies to attack Indian children. I think it was mentioned in the opinion, but it's been thrown out there a lot that the policy of the boarding school era was to kill the Indian, save the man, right? And so I think it's not, sorry, there's thunder in the background. I think I'm ThunderClan. I feel like my family's agreeing with me here. But they go for the most vulnerable because they're the most valuable, and that's our kids. So this is not the first attack. It's not going to be the last attack, unfortunately. But we know their tactics. And I think that something that's really important to note, though, is that this is not the first time that equal protection has been brought up against Native peoples. It's been brought up multiple times, and equal protection hasn't, the equal protection argument hasn't won because it is not a race based. It's based on our political status as citizens of a sovereign nation. We've seen that in Morton versus Mancari. We've seen that in the Antelope case. We've seen that in other cases that the Supreme Court has already decided on. And so I have some hope. One, because we've got so many cases that say this is not a race-based, this is not racial discrimination. And two, because nobody else joined in his concurring opinion. That was pointed out to me, and I think that's a really fair point that needs to be disseminated more, is that nobody else joined in his concurring opinion. He was by himself, and he didn't have enough to write on it, so that matched a page. I think the title saying it was a concurring opinion was longer than his actual words. So I think that we've got some hope, but that doesn't mean that with the way that the Supreme Court has been ruling against precedent recently, that we can let our guard down either.
So I've seen Jill unmute a couple of times, and so I feel like she's got something to add.
No, I think, everything that you guys are saying is so spot on, and I just really love hearing you guys talk about this. I was thinking about your question, though, Misty, about tribal sovereignty, and just kind of wanted to point out for anybody who hasn't already listened to Rebecca Nagel's podcast called This Land on Crooked Media. Rebecca is a citizen of the Cherokee Nation, and she has a podcast that during the first season talked a lot about the Baby Veronica case that the U.S. Supreme Court decided in 2013. But all of her season 2 is based around this case, but it goes into the broader context of what everyone is talking about as far as the tearing down of tribal sovereignty being the overarching issue that really it seems people are trying to attack by going after ICWA.
Thank you. Yes, I agree. That podcast is excellent. Rebecca Nagel, she hits it on the head, the nail on the head with that. Thank you. I did want to talk a little bit more about tribal sovereignty, but I just wanted to check in with you all to see if you have anything else you wanted to say about, the Indian Child Welfare Act, the importance of it, and I know, because I know you've said like this isn't going to be the last attack, but wanted to see if there was anything else you would like to add about the Brackeen case or ICWA.
Yeah, sure. I'll throw something out there because I think the attacks by the opponents, and they're the same ones. They're the same folks every single time. They take the same playbook. And so I guess just to arm the listeners with some of the ironically racist statements that the opponents to ICWA make. And it's pretty clear that the playbook they follow, they will try to demonize tribes as commodifying children. They will demonize Native people, and it's interesting because if you take a step back and just pretend for a moment that a tribe in a foster care proceeding is, I don't know, we're in Nebraska. Compare like this, the tribe to the state of Iowa. We don't really like, if a bad foster care or bad outcome happens in a foster care case in the state of Iowa, we fully expect it, or in the state of Nebraska. And so it's interesting because like these institutes and places will cherry pick examples of, honestly, in almost every single case, a screw up by one of the attorneys or judges in the case and say, look, there's a bad outcome here. It's ICWA's fault. The tribe is like trying to steal these children. We're in a happy place. But we don't really do that. We don't show tribes the same sort of respect that we do the state of Iowa. We point at the tribe and say, look, the tribe's incapable of doing these things. The tribe's fault. This is like Native people are not capable of raising their children. And it's the same sort of thing. They'll go on Dr. Phil, they'll go on talk shows, they'll try and make this like rhetorical argument. And if you just take a step back and just pretend for a moment that just as the US like Constitution mandates that tribes are a sovereign government, it's kind of inherently racist that we just sort of impart all of these things on another sovereign government, honestly, just because they're run by indigenous people. And so that is one of the common, I think, tactics used outside of the courtroom, is to try and in the war of the media, portray Native people as trying to put the tribal interests above those of the children. And I would just like to remind people, indigenous people have been successfully raising children long before the United States became a thing. And they will continue to successfully raise children long after the United States ceases to be a thing, hopefully. And so I would just remember, Native people care about kids too, regardless of what you hear on a talk show or the opponents of ICWA. Like, tribes are a sovereign entity. We should be giving tribes the respect that we give the state of Iowa or the state of Georgia in making those sorts of determinations for their own government. And remember that Native people also care about kids too, because sometimes this sort of gets lost in the conversation.
I wholeheartedly agree with that. That's my job, is to go in and I represent my tribe in state court. And the amount of times that I've heard from people, some microaggressive, racist comments against tribes, I'd be so rich if I had a nickel for every time. And I don't know that they intentionally say it, or if it's just kind of free flowing from the mouth because of society. But either way, the amount it's uncanny, the microaggressive racist comments that I see. But the point that I want to make is that ICWA, for some reason, has become a 4-letter word in state courts. And the point that I want to make here to the audience is that tribes and states could get along if states realize that tribes have the best interest of the child at heart as well. We just include what the Indian Child Welfare Act statutorily puts in there. Inherently, tribes already practice it, is that cultural element, that cultural piece, because that cultural piece includes the definition of what family is. And I think that's what the tribes in their arguments hit on in the oral arguments with the justices before, is that definition of family for that purposes of placement preference is so necessary, because that definition is a lot broader in tribal settings. But just the best interest of the child is a common denominator between tribes and states, and if we give deference to tribes as ICWA allows for, we can be on smoother ground with county courts.
And Misty, if you're okay with this, I'm going to jump in here, because prior to jumping onto this live, Lexi and Robbie and I were talking about how the Nebraska ICWA actually provides strengthened provisions greater than the federal ICWA, which is actually just intended to be minimum standards, right? It said that in the law, minimum standards. So I want to give both of them an opportunity to talk about how the Nebraska ICWA provides strength and protections. And I was reminded of that when Lexi brought up best interest, simply because we actually have a definition of best interest in our law. So,
Well, and I think, so I know, Robbie, you worked on this, the Nebraska ICWA, so I'll defer to you with that. But I think something that Justice Tony Barrett brought up was who has the burden for diligent search. And she said that the burden for diligent search is on any party, including tribes, including private parties and states. That is not the case in the state of Nebraska. The state of Nebraska adopted laws, so the state of Nebraska can enact higher protections and it still be constitutional, because the Constitution, or sorry, the Indian Child Welfare Act set those minimum federal standards. We can go above and beyond in the state of Nebraska, and we do, because it puts that diligent search burden on the state, and because it's a state law, the state has to, those state agencies have to follow it. So any concerns that I think it's like a couple of lines saying, hey, this is also on the tribes. It's not the case in the state of Nebraska. And I think that the federal regulations also say that. It's not mentioned in the opinion, but the federal regulations also say that diligent search must be made, and that it implies that there is a burden on the state to do that. But Nebraska has a higher safety net than the federal statute.
Yeah, we do, and it's an interesting. You probably can do an entire podcast on the history of Nebraska state law, maybe even a couple of them, because it was a wild adventure. But to make a very, very long story short, we do have higher protections in our state, and we spell out definitions of active efforts. Best interests of the child is specifically presumed to be in compliance with federal and the state ICWA. And then also we spell out all the extended family. We have a broadened definition of extended family. We have a lot of additional things in our state. And again, it is as Justice Gorsuch adequately points out, you can fully comprehend and agree that tribes should be sovereign entities by reading the Constitution, and also be conservative. I will point out, Nebraska unanimously passed our state ICWA with heightened protections in a government-to-government relationship with tribes. And we are not, if you live here, you may know, we are not the most progressive state in the country. So you can be conservative and still support the existence of tribes and Native people and the protections that state and federal law provide in that government-to-government relationship. So I do think the protections in 566 specifically, I will say, for those that are concerned about this equal protection and the same type of case being brought here in Nebraska, in a juvenile court case, for example, all of you opponents of ICWA that may be listening to this out there, Nebraska, foster parents do not have legal standing to make those arguments in any case, whether it's ICWA or not in our state. Foster parents do not have the ability to come into a juvenile court case and assert that they have interests that are on parity with a parent or a tribe. They just can't do that in the state of Nebraska. And so for anybody that's attempting to try and make a copycat case in Nebraska, they're going to have additional barriers to try and do that here. So they'd be better off sticking to Minnesota, Texas, Arizona, because they can't do it here.
yeah, thanks. And the only thing I would add to that, Robbie, is in our definition of best interest of an Indian child in the Nebraska ICWA, it's maintaining that political, social, and cultural connection for that child with their tribe and their tribal community. So not just compliance with federal and state law, but those maintaining those connections is critical, because as we all know, culture is a protective factor.
Yeah. I will throw one other thing out there too, because this is, I think, a good example of how Congress, in passing the federal ICWA, recognized that states can have higher protections than the federal ICWA. So You mentioned the baby Veronica case that was in 2013. One thing that our state law does is overturn what the U.S. Supreme Court did in the baby Veronica case. In Nebraska's state ICWA, and our Supreme Court has recognized this, there's an additional responsibility to not only reunify a family that has been separated, but to unify. And the exact example of the baby Veronica situation is a non-custodial dad that didn't have a previous custodial relationship with a child. ICWA still applies in Nebraska to that. And so Congress recognized that states can go above the floor, which we did in Nebraska. So baby Veronica can't happen here because our state decided we didn't want that to happen unanimously, again, as a state. So like, it's a good example of, like, in the broader context of federal Indian law, like, Congress has plenary power to regulate the affairs of Indian nations, but they gave states power to give tribes additional respect and additional rights, which is what we chose to do here. Because again, hopefully we are taking maybe a second step towards remediating the damage that we've done for the last 200 years to, like, Indian nations in Nebraska. Again, it ain't done. It's not even close, but you certainly can't take a step backwards, which is what the federal law protects.
I appreciate all of your insight into this. And, you know, I learned something new today, and I've actually learned quite a few things new today, or that I may have forgotten about. But, and I know we've been talking a lot about tribal sovereignty, and, you know, because that is just, it's just really big in my mind. And I know I've heard some people talk about, well, you know, this is not like the last attack on ICWA and the last attack on tribal sovereignty. So I was wondering what your thoughts are about, like, what do we do to help protect ICWA and to protect our tribal sovereignty? So any thoughts about that?
I think that something that is important is that, and I hate to say this because I feel like Indigenous people, especially, we just carry a burden of education, and that shouldn't be the case. But I think that educating the players, and I know that NICWIC is doing this, educating the players in these ICWA cases is a big step. You know, making sure that the county attorneys and the DHHS attorneys and the DHHS caseworkers and the judges all understand the different facets of the Indian Child Welfare Act. And I think something that has been really helpful when I've done trainings is making sure that they understand why ICWA is in place. I don't think people make the connection between, well, I don't think people know about boarding schools very much. I think it's becoming more apparent in the news, but even then, they're just kind of, when you think boarding schools, you think like Harry Potter, you know, you don't think of the atrocities that happened at the federal Indian boarding schools, these militarized boarding schools, right? So I think there's a disconnect between the origins of the law and the law itself, and then the practice of the law. And so I think that education is a huge piece to that, and making sure that our tribes have the capacities and the capacity that they need in order to represent the tribe's interest and the children, our children in court. Just making that connection, and I'm grateful to NICWIC for their work in furthering that along. I think that if we just get more people involved that understand, then we'll be on a right track as well. And I think that's what Gorsuch did in his opinion too. You know, I think that's why he did it, because Amy Coney Barrett, I'm not going to talk about her writing. I think her writing is interesting, but Amy Coney Barrett just kind of outlined the law and said, here's our reasoning, but Gorsuch is like, here is why. Here is the legislative history. Here's the policy and the history behind that policy. And then he called it a story. He said, this is the story, this is the narrative of Indigenous peoples in the United States. And I think that is so important, is taking back that narrative, kind of going back to what you said, Robbie, too, that there's a history of the states not giving that respect of tribal authority, and that's because we've never had that. We've never been the narrators, right? The states have always kind of overshadowed what tribes history has been. I think that you learn state history in 4th grade, and that's it, and that's the only time you learn about natives ever in history classes, until maybe like a smidgen of it in high school with US history. But there's a severe lack of education on Indigenous peoples, not only our history, but who we are today. Going back to what you said again, Robbie, with the stereotypes in social media, and I think that that there's just a lot of fighting that we still have to do, and I hate to say it because we've been fighting for a long time, and that fight includes that educational piece. So
Yeah, I completely agree, Lexi. And the burden of educating like the dominant white population about not even just like the rights of ICWA, but just the mere existence of Native people should not be. You shouldn't have to remind people like, hey, I'm Indigenous, I'm here. But that honestly, like the continued presence, and I think this is one thing that NICWIC does so well, just in the ICWA context, just the continued presence with all of the juvenile court stakeholders, super, super important. Juvenile court attorneys forget stuff frequently. Sometimes they stop being juvenile court attorneys and you have new ones. And the continued education for judges, attorneys, and casework, especially kids, there's a high caseworker turnover within the department. Just the continued efforts for an organization like NICWIC to continue to remind people specifically on the law, why it's here and how it's important is critical. Otherwise, if you just did it one time, say when we passed LB 566, we did a real big training effort, trained everybody up on the law 6 years ago, you would have almost no judges that are still there in juvenile court. You'd have some. They might remember one training that you did 6 years ago. And caseworkers, there'd be very rare to have a caseworker that was at a training 6 years ago that's still a caseworker at the department. And attorneys certainly may not have been paying attention. They were probably checking their emails during a CLE. So continued presence specifically on the law and education, really important in this context, but just continued presence and voice from Indigenous peoples is critical. Like Lexi said, sometimes white people forget that Native people exist and that they raise children successfully, and that they care and they have like hopes, dreams, and interests. And I think a decent example of sort of the importance of the overall story, it was sort of lost on me in law school. One of my favorite classes was federal Indian law. And I had a professor named Professor Snowden at the University of Nebraska, who started off our federal Indian law class by reading us a book. We started and he didn't explain why. I was like, this is really interesting. This guy is like spending the first hour of a law school class having like story time. There was a book called The Navajo Way, and he read out of it for like an hour to start every single class. I'm like, what is this guy is bonkers? What's going on? But the broader context in the legal understanding of just understanding the story of the interaction with Native persons and the United States government and state government and like white people is really kind of critical to understanding all of the different components that intersect with our law. Like federal Indian law is very complicated. Thank God Justice Gorsuch actually understands it. But it is really critical to just continually remind folks that Native people have a story and we are here. There's an existence. I'm not Native, but I try to do my best to remind my colleagues that federal Indian law is important. Native people exist. And so I think just that in and of itself is important too. Like protecting tribal sovereignty is just continuing to show up and express your voice.
I think that's really important, Robbie, to say that we need advocates, native and non-native, because Jill and I have that conversation all the time when we're training, like what's going to be better heard if I say it or if she says it. And so that's where I feel like, like we're a good team and we complement each other. And I really, really appreciate that, because we do need not those non-native advocates, because some things are heard better coming from white people versus, if it was coming from a native, and vice versa. There's other things as well. But Jill, did you have anything you want to add on that?
Well, I was just going to ask that before we wrap things up, if I could talk a little bit more about Justice Gorsuch's concurring opinion and kind of end us with that. But I just want to make sure everybody else has a chance to say something.
Yeah, I appreciate that. Yeah, I was, when we were out in Washington, D.C. For those oral arguments, and when they'd had a debriefing afterwards, and there was a couple of things that I felt like Kate Fort said that was, that stuck out to me when asked that question. And she said, like, it's important to empower and strengthen our tribal governments, including especially like our tribal courts and our tribal programs, so that we can be transferring cases more often. Because if we have them in tribal court, like these challenges against ICWA aren't going to, they're not going to arise if we're handling them within our own tribal court. So that was one of the points that I wanted to make sure we get across today, because I feel like that's important, and that in itself is such a huge task, right? And I just knowing, like, working for my tribe and the tribal courts and all of the things that, all of the resources that are lacking for our tribal programs and our tribal courts. And so that was one of the things I wanted to get across. But yes, I think we've got like 5 minutes left, so I think we can go ahead to go with Jill and talking about Gorsuch.
I have one more thing just on that note, and then go into Gorsuch. The other thing so as white person speaking to all of you other white folks in Nebraska's like court system, the next time that you have Lexi in court, pretend that she's at the Attorney General's office for another state. That is like the respect that tribal nations and tribal people should have. Just pretend for a moment that that's the way it should operate, because that's what the Constitution commands you to do. So just think about that from white person to another white person that might be listening to this.
Thanks, Robbie.
Lexi, do you have any last things?
I think that this, I want to take the proper time to celebrate this opinion and this decision. I think that we've kind of been dissecting a little bit and talking about the things that can scare us. But I do want to emphasize that this is a really big win for Indian country, and we've touched on those reasons why. And we've also, it was shocking, and I think Robbie, you talked about this too. I was shocked that it was such the majority opinion was 7-2, right? The 7-2, it means the only two people that didn't agree we knew that they weren't going to agree. Right? Like when you saw Alito and Clarence Thomas, you were like, this makes sense, right? I think that Gorsuch, obviously we knew about, we had an idea about Sotomayor and Kagan. Justice Jackson is relatively new, but we had a thought that she would be on our side, but we still had a lot of factors at play that we didn't really, and by factors, we had a few justices, we had no idea how the pendulum would swing with them, but we had a thought. And I thought if we were to win, there would be it would be piecemealing ICWA, and it would be a narrow 5-4 decision. If we were to win, that would tear apart certain aspects of ICWA and just decrease the strength and protections. But it didn't, and it's upheld in full force. And even though we have battles coming, I think it may take a little bit for them to get the perfect family to agree to do this, because it's got to be really specific. So I just want to recognize that this is such a big win, and it wasn't a narrow win; it was pretty wide girth wind, wide girth win. So, and then if we're ending on Justice Gorsuch, he's got some beautiful words about tribal sovereignty, and he writes the book on federal Indian law in this case, and so I'm just really appreciative of how it went versus how it could have gone.
Yeah, thank you. And you know, if anybody out there listening is curious as to why we keep referencing Justice Gorsuch, please go take a look. Maybe LaToya can drop into the feed about a link to the opinion that came out. The full court opinion that Justice Barrett wrote was 34 pages. Justice Gorsuch wrote 38 pages. And he wrote it in a narrative, which I find very, I don't know what the right word is, but, you know, Native people are storytellers. And he wrote it in such a way that it's a story. And it's not some dry legal opinion that isn't going to make sense to like the majority of people. It will totally make sense. And I encourage everyone to read it. Like Lexi said, it's a great primer on federal Indian law, the relationship between the United States and tribal nations as sovereign nations within the nation. And so I'm going to end with his last paragraph, if that's all right. Often Native American tribes have come to this court seeking justice, only to leave with bowed heads and empty hands. But that is not because this court has no justice to offer them. Our Constitution reserves for the tribes a place, an enduring place in the structure of American life. It promises them sovereignty for as long as they wish to keep it, and it secures that promise by divesting states of authority over Indian affairs and by giving the federal government certain significant, but limited and enumerated, powers aimed at building a lasting peace. In adopting the Indian Child Welfare Act, Congress exercised that lawful authority to secure the right of Indian parents to raise their families as they please, the right of Indian children to grow in their culture, and the right of Indian communities to resist fading into the twilight of history. All of that is in keeping with the Constitution's original design.
Thank you so much, Jill. And thank you so much, Robbie and Lexi, for joining us today and talking about this very, very important case upholding the Indian Child Welfare Act and helping us to dissect it a little bit and what does it mean for Indian country and the Indian Child Welfare Act, the sovereignty of tribes, and also reminding us, Lexi, to sit in this accomplishment and this victory. And it is such a huge victory. And I don't want to start talking about it because I don't want to start getting emotional again. But it is such a huge victory for Indian country and for Native families, like you all have said. And so thank you again for joining me today and the Nebraska Indian Child Welfare Coalition and talking about this very, very important case.
Thank you everyone for watching. If you have any questions or would like to know more about NCWIC, please visit our website at www.ncwic.org.